There we go. Welcome, everyone. I would like to begin by acknowledging the Indigenous peoples of all the lands that we're on this morning. I come to you from the land of the Matagami and Matachewan First Nations in the Treaty 9 territory. I would ask that if you have any questions, Luke and Renee have agreed to answer them as we go along, but ultimately you can put them in the Q&A box at the bottom of your screen. Welcome to our session entitled Legal Steps to Expect in Succession Planning, and I can't think of anybody better than Luc Maisonneuve and Renee Maisonneuve, of course, joining us from Maisonneuve Dawkins law firm, and we're very pleased to have this session today. Ultimately, we're going to be able to understand what types of, business transitions are going to occur upon death, including a discussion on wills, powers of attorney for business owners, succession planning with multiple shareholders, including a discussion on shareholder agreements, and steps to expect when buying or selling a business. At this point, I would like to acknowledge the succession planning pillar partners, Jenny Financial, MNP, and of course, our presenters today, Maisonneuve Dawkins. And with that, I will leave it to the both of you. Luc, Renee, thank you so much for joining us today, and I'm really looking forward to our presentation as we go along.
Thank you, Cameron. Renee and I are really happy to be here this morning. This is a follow-up that's intended to follow in the steps of what MNP presented some time ago. We had Renee, Luke, and Joel from MNP talk about some of the tax implications of succession planning. So we want to kind of follow in step with that and give you a kind of a legal outline of some of the issues that come up when you're planning for a transition eventually in your business. We presume in much of our presentation that the business that you have is incorporated. A lot of what we're going to speak about presumes that you're incorporated. There could be some subjects such as wills and powers of attorney that will apply whether or not you're incorporated, but incorporation is kind of a presumption that we've taken. So if you're not incorporated, there might be a little bit of tweaking to do to some of the topics that we're discussing. So again, we want to follow up on the tax presentation from MNP, and we thought we'd cover 4 subjects, and Renee and I will just kind of take turns presenting these 4 items. So first of all, the first area we'd like to address is the transfer of a business to a third party. So this would be to a stranger, a non-related family member. You're not transferring your business to an employee or someone who's closely related to you. This would be the outright sale of a business, and we'll cover such things as the process that we're going to follow and what you can expect in buying and selling a business in a third party situation. We'll then talk about transfers to family members, which have the same kind of consideration, but additional considerations when transferring to family members. Thirdly, between shareholders, and what we mean here is perhaps a transfer to an existing partner that you already have in your business, or a transfer, for example, to an employee where you will perhaps stay on as a shareholder until you're paid in full. And then finally, transition that can occur on death. And we'll be giving an outline of some of the estate planning issues, such as powers of attorney and wills and that kind of thing. We don't intend it to be an estate planning presentation, but rather where the estate planning and business transitions kind of overlap and intertwine somewhat. So I understand we have about an hour and a half, so we want to get through that. Please ask questions anytime. Sometimes there's something that might strike you at that minute, so put it in the question section, and we'd be please take a little sidestep and answer any questions. So I'll start off with the sale of a business to a third party. And we often get questions from business owners just generally as to the practical steps that have to be taken on the sale of a business to a third party. And we thought we'd go through some of the principal steps that we typically go through in the negotiation and implementation and closing of a sale to a third party. So typically, the first step when you're contacted or you reach out to a third party with respect to the sale of your business is that the purchaser will, of course, want to go through your financial information, conduct a review of your financial statements, be informed as to what your clientele is like, what are the gross revenues, and know something about your business. And you'll be reluctant as a seller to just disclose any information to anyone, and you'll want to be sure of some confidentiality provisions. This will typically be dealt with through what we call an NDA, or non-disclosure agreement. So this puts you in a position as a vendor to have the potential purchaser agree to strict confidentiality requirements, so that when you disclose your financial information, they're bound by very serious covenants to not share the information, return it to you when they're done, and to distribute it only to people who need to know, such as their accountants and their lawyers. So we see this kind of thing in some agreements. Sometimes those discussions are a little bit more informal, where you might know the potential purchaser and you're okay on sharing information without this kind of covenant. But if there's more serious concern, we cover that up with a non-disclosure agreement. When your purchaser has serious interest in purchasing and wants to commit, ultimately the relationship between the buyer and seller is going to be governed by a purchase agreement. And these can be 20, 30, 40, 50, 60-page monster agreements that are drafted by the lawyers heading into closing. And your agreement with your purchaser will be governed by this agreement. And now, before getting to that stage and having lawyers and accountants prepare these agreements, often the parties will just want to have a handshake agreement and agree to the basic terms before getting into all of the effort of drafting the definitive agreement. And rather than just have something agreed to in verbally, the purchaser and the vendor will typically draft up a letter of intent. And that's intended to be a gentleman's agreement. It might be 3, 4, 5, or 6 pages long, and we'll set out the basic terms of what the parties have agreed to. Typically, we'll see it'll pinpoint what's being purchased, what's the purchase price, what's the closing date, are there non-competition covenants, what are we doing with the employees, what are we doing with things like receivables, do we need to do any adjustments to the purchase price ultimately, is the vendor staying on as an employee, as a consultant. So these 7, 8, or a dozen so main points are outlined in a letter of intent. It's typically not binding on the parties, but it's meant to allow the parties to agree to the basic terms and know they have a basic understanding as to what we're doing before lawyers and accountants are engaged in a serious fashion to start drafting the definitive share purchase or asset purchase agreement. Once that letter of intent is signed, the purchaser will often move into more serious due diligence. And this can be done at this stage, or it can be done even after your definitive share purchase or asset purchase agreement is signed. And this will allow the purchaser now to thoroughly investigate the business. They might want to look at all the receivables, do an environmental assessment of any real estate that's involved, review leases in detail, review if you're unionized collective agreements, in every aspect of the business that they want to investigate. The fourth step is then the discussion surrounding whether or not you're selling the shares or selling the assets of the business. And I think Renee has a slide. Yeah, here we go. Whether you're selling the assets or selling the shares of the business. And Renee went on to explain thoroughly last time Renee DeRoy from MNP, the difference between the two and some of the tax implications of the two. But just to summarize again, at one point in consultation, primarily with your accountant, to understand the tax issues. The buyer will either buy the shares from you, and the buyer will become the shareholder of the corporation who owns all of the assets, or the buyer will buy the assets directly from the corporation, at which point you as a seller, you still own your corporation. You might retain some assets in your corporation, or do you just have a corporation now that has no assets? Typically, a vendor, for some of the reasons that Renee explained last time, particularly in relation to the capital gains exemption that's available to the seller. So typically a seller will want to sell the shares, and there's significant tax reasons for that. And typically a purchaser will want to buy the assets. So there's a bit of tension there in that debate, and typically it's not necessarily that one is better or worse than the other, but the parties will land on either an asset or a share sale. We typically do an equal amount, I'd say, perhaps a few more share sales, but asset sales are very common as well. And it all depends where the parties want to land on price and on the tax implications. And it's not unusual for the buyer or seller to consider different sale prices depending on whether it's an asset or a share sale. So your tax advisor may advise you that you could sell your business on an asset basis for $1.3 million, but you'll actually come out in a better net position if you sell the shares for $1 million because of the net tax consequence at the end. So in the letter of intent, parties will usually address this issue and say, look, we're going to buy through an asset or a share sale. We conduct some due diligence, and either the asset purchase agreement or the share purchase agreement is going to be addressed. Now, some of the issues that are addressed or items that are addressed typically in these kind of agreements, and it can be lengthy, but they need to be properly addressed, particularly to protect the purchaser from different consequences can flow from the purchase, but also to make things clear for the vendor. And you'll typically see in an agreement a lot of language in relation to the tax liabilities of the corporation being paid by on closing or by closing. If it's a share purchase, the agreement will address employment issues, labor issues. What are we doing with the employees? Who's accepting liability for all the accrued seniority of the employees? Is the buyer going to take that on? Is the vendor assuming that liability? Or the employees going to be retained, or they're all going to be terminated? Non-competition covenants, the vendor or the purchaser rather will invariably want to see the vendor bound by non-competition covenant. You don't want to buy a business and find out that your seller has opened a shop in competition with you across the street. We'll often have excluded assets, so you as a vendor, whether it's through a corporation on a share sale or on an asset sale, there may be assets that you don't want to sell that you want to retain, and these items can be addressed in either the share purchase or the asset purchase. Like buying a used car, as a buyer, you want some form of warranty on what you're buying, and the purchaser will usually insist on the vendor making a number of representations and warranties with respect to the business. So although it's part of the due diligence conducted by your lawyers and your accountants to make sure there are no skeletons in the closet that are going to pop up later, we still require the vendor to make representations and warranties as to the business. And this can be everything from saying, my employees are paid up to date. I'm not aware of any environmental contamination on my land. All my HST and source remittances are paid. I'm not being sued. I've got no outstanding insurance or WSIB claims. I'm not in litigation. All of our income taxes are up to date. I haven't received any notice from CRE, that sort of thing. And the vendor will be liable post-closing for different periods of time if some of these representations and warranties turn out to be untrue. So protection there for the purchaser. You then have a number of practical considerations that will come up if you are transferring, for example, a trucking company, and it's on an asset purchase. You have to change over all your CVORs, you're changing over ownerships of equipment and vehicles, you're opening new bank accounts, that kind of thing. The purchaser will be going through different forms of potential financing. They're going to go through a process that can be lengthy. And as a vendor, as part of your succession plan, you'll have to expect that the purchaser will have to go through his or her hoops with a potential lender to land somewhere on some kind of good financing. The vendor corporation might have investments and cash in the company that it needs to withdraw before closing. That'll have to be addressed. So there are all these practical considerations that need to be addressed in the course of the negotiation of the agreement and heading into closing. And this is what the lawyers will typically stick handle with you to make sure that we've crossed off everything on our checklist to make sure there are no practical issues that pop up on closing. So that's pretty much just an outline of the roadmap that you're going to go down if you're thinking of selling to a third party. Renee is going to talk about if you're, the incidents that come up if you're selling to a family member. So some of these considerations still apply, of course, but there are certain kind of differences that may come up. So I'll let Renee talk about that.
Were there any questions before I start with transfers to family members?
I don't see anything in the chat just yet, so you're good.
Sounds good. So like Luke, my dad said, a lot of the items that he discussed will apply to transfers to employees and family members, but certain things will differ. So in terms of steps to expect, often you won't have a non-disclosure agreement or a letter of intent when you're selling to a family member or an employee, particularly if they're already involved in the business. So they already have knowledge of your financial situation and your receivables, your clients, and so on. So often the parties will already have an agreement on the purchase price and kind of what they want to do before they go see an accountant and a lawyer. But it's still important to consult an accountant right off the bat to determine how the business will be transitioned. So like with a third party, you can do just an outright sale of shares or assets. A sale of assets would be a little bit more unusual when you're selling to an employee or to a child, because often the parent will want to take advantage of the lifetime capital gains exemption. And you only get that tax-free money on a sale of qualifying shares. You don't get to take advantage of that when you're selling assets. The other option that we see sometimes, and not as much now, would be a freeze. So a freeze is when a parent will exchange their common shares, which are their equity shares, their growth shares in the corporations, for preference shares. Preference shares usually have a fixed value and the corporation will buy them back over time, and that's how the parent will get paid. So the fair market value of the corporation at the time of the freeze is transferred to those preference shares. So in the example, if the parent has 100 common shares worth $1 million, they're exchanged for 1 million preference shares worth $1 million. And those don't fluctuate if the company's value increases to $2 million. The child would then buy shares of the corporation, and the child would own the growth of the corporation. So at the time that the child buys the shares, the fair market values of those shares is essentially $100. It's nothing because the fair market value of the corporation is tied into the parent's shares. And then over time, the corporation would buy back the preference shares from the parent. So the profits from the corporation are used to pay the parent. And this can be good when the child doesn't have the cash on hand to pay the parent, and the parent wants to stay on in some capacity. So in this kind of situation, the parent might have voting preference shares where they get to keep controlling the company until all the preference shares have been bought back to ensure that they do in fact get paid and that those $1 million shares don't stay in the corporation forever. Recently, tax law changed in Canada, and children can now buy shares from the parent without incurring negative tax consequences. So until recently, it was very difficult for a child to buy shares from the parent and for the child to use a buying corporation to do that, and for the parent to still take advantage of the lifetime capital gains exemption. So a parent could sell to their neighbor and not have any negative tax consequences, but as soon as they wanted to sell to their child that's been involved in the business, there were negative tax consequences. This changed recently, and under certain circumstances, children can incorporate to buy shares from their parents. There are some specific rules to follow. So for example, you have to have a third value the shares and determine their fair market value. So they don't want the parents to be giving discounts to children. And then the children has to hold on to those shares for a number of years. So the child can't buy the shares to allow the parent to take advantage of the lifetime capital gains exemption and then immediately flip them over to someone else. But this is something that an accountant would work through. And with your accountant, you would determine what the best way to proceed would be. Some other issues that might come up with transfers to employees and family members is financing. So typically when you sell to a third party, you want to get cash on closing. So the third party would go to a bank, get some financing, and you get the full purchase price when you close the transaction. That's not always the case when a parent sells to a child. Often what's going to happen is the parent will lend the money to the child in the form of a promissory note. So the child gives the parent an IOU, and from the profits of the corporation, after closing, the child over time pays back the parent. So that way the child doesn't have to go take out a high interest loan to pay the parent. And often the parent is okay with staying involved in the corporation after closing. But that's not always the case. So if there is the cash available to pay cash on closing, the parent may say, I don't want to be involved anymore. I want the cash and I'll walk away from the corporation. But involvement of a parent or an employer after closing is another issue to discuss. Often when there's a sale to a third party, there will be some provision for the seller to stay on in some capacity to help with transition. Well, when the sale is to an employee or a child and the seller hasn't been paid yet, the seller might want to stay on and keep control of the corporation. A parent might also be reluctant to sign a non-competition agreement, and the child might be reluctant to ask a parent for a non-competition agreement. I see that we have a question. Okay, a comment. Sounds good. So I'll continue. Oops. Sorry. A little technologically challenged, and I'm the tech assistant between me and my dad. And then another consideration is other children. So if you have multiple children and you only have one child involved in the business, sometimes you do want to consider what happens if the child still owes me money for the shares that they purchased and then I die, or I'm incompetent, or that child goes bankrupt, or that child gets divorced. So those are discussions to have with the child and potentially with the other children as part of the closing of the transaction. Pass the baton over to my dad for transfers between shareholders.
All right, thanks, Renee. Just to tie in, Renee mentioned, consulting with accountants, and I just thought I'd put even more emphasis on that. We often get clients that come in and they consult with us to start the process of selling their business, and almost all the time we'll advise them, first of all, to consult with their accountants and tax advisors. These people are invaluable. Fellows like Luke and Joel and Renee DeRoy that spoke to us at the last session. And that's usually the starting point in getting things going with respect to sale. And the questions to ask the accountant at that time is, number one, what's my business worth? I've got an offer here. Does it make sense? Number two, what are the ways I can sell it? And what's the difference between a share and an asset sale? And where am I going to land tax-wise after all this is said and done? Once you're accountant and you have determined that the purchase price makes sense and you understand where you're going to land and end up on a net after-tax basis following the sale, depending on whether you do an asset or a share sale or some transition with a family member, then it's at that point that we can start looking at letters of intent and drafting agreements and coordinating sales. So just again, not to be repetitive, but your accountant is probably the key person to start with when considering this kind of transaction. So on to shareholder agreements. And some of you may be familiar with these, some of you may not. So forgive us if we're telling you stuff you already know, but these become very important in different kinds of transactions. Now, usually we'll talk about them in existing businesses and you've got different partner shareholders and you want to organize your affairs and your dealings with each other. But here we'll focus a little bit more on succession planning and shareholders agreements. So when will these come up as part of a succession plan? So if you're selling to a third party and you're paid in full in cash on closing and you're walking off into the sunset, then these things won't apply. But you may be looking at a shareholder agreement if you remain as part of the business as a shareholder, as Renee said, as a parent, and you're a co-shareholder with one or more of your children. And the shareholder agreement needs to be in place to govern your relationship going forward. Number two, you might be selling to an employee, an associate in the business, and the deal is that you're going to stay on as a shareholder until you're paid in full, perhaps by a buyback of your preference shares. And again, it's important to have this shareholder agreement in place. So what does the shareholders agreement do? Well, it's essentially a prenup. Consider yourself married to your co-shareholders, and someday there might be a nasty separation or divorce, and you want to have an agreement which governs what is going to happen when things go bad, or if some particular event comes up and you need to address that in a shareholders agreement. The agreements cover a broad number of items, and absent a shareholders agreement. So if there's no shareholder agreement, the law is a little bit thin on the rights and obligations of shareholders when disputes come up. And there is not often an easy mechanism to resolve disputes. If we're just looking at a strict application of the Ontario Business Corporations Act or the Canadian Business Corporations Act and common law. So the shareholder agreement is intended to cover these holes that may not be covered by the law generally. So it's a prenup, and usually it'll address a number of areas. First of all, it's the agreement will usually cover what's called areas of that require unanimous consent. So these are decisions that may be made in the governance of the company where unanimity will have to be had before we move forward. So for example, we will agree that without everyone agreeing on a unanimous basis, we will not change the nature of the business. So if you got a trucking business, we don't open a flower shop unless everybody agrees, all right? We are not going to change the number of the directors. We are not going to make loans. We are not going to incur debt. We're not going to dissolve the company. We are not going to bring in other shareholders. et cetera, et cetera. So these basic kind of fundamental decisions that may affect the company, typically shareholders will agree that that we will not make these decisions or determinations unless we all agree. We will be looking at what contributions may be made by the shareholders if the company needs capital to finance its operations. The shareholder agreement will address restrictions on shares. So this can be fairly broad. What do we do if one shareholder wants to sell his or her shares? Does the remaining shareholder or shareholders have a right, a first option to purchase? Can they block the sale? How do we deal with that situation where one party wants to sell? We may deal with management issues. Who will be in what position, who will be appointed as manager, and any other particular item that you want agreement on. So going forward as shareholders, and it can be, the agreement can be malleable, it can be broad, you can be creative with it and address issues depending on the needs of your corporation. So we have these unanimity provisions. We'll have these management provisions. There might be restrictions on whether or not one person can sell shares. And then we get into particular situations where one person might want to sell shares and the other doesn't, or one wants to sell the business and the other doesn't, and that kind of thing. So the agreement can provide, and you might have heard this before, for a shotgun provision. Some will call this a buy-sell provision. And essentially the way this works is that you're at an impasse with your quote-unquote partner. You can't stand each other. You've got serious disagreements, and it's either he goes or she goes or I go. And it's a Mexican standoff and you're at a standstill. Very difficult if you don't have a shareholders agreement in place, because then you're just turning to the skinny provisions of the Ontario Business Corporations Act. If there's a shotgun provision in the agreement, the way it typically works is that if I want to trigger, assume Renee is my co-shareholder here, God forbid, but she's my co-shareholder, and we don't get along, and it's either she goes or I go. And what I do is trigger the shotgun to her. So I would say, I think the shares, our business is worth $1 million. She's a 50% shareholder. So I will trigger the shotgun and say, the shares, I trigger the shotgun at $500,000. So I've set the price, I've triggered the shotgun, and Renee would have 10 days to decide if she buys my shares for $500,000 or if she sells her shares for $500,000. So I've set the price, but I don't know if I'm buying or selling. So I have to be reasonable in my approach, and I have to be willing to accept to sell or buy. And Renee makes the determination on selling or buying. If she doesn't, then the agreement provides that I get to choose. Once that selection is made, we're bound to either sell or buy the shares of the other shareholder. And that essentially boots up one of the shareholders. And that's why it's called a shotgun, because it's a drastic gun to your head, last minute kind of approach to dealing with the solution. So depending on your situation and how you're set up in your succession plan, it may or may not be appropriate to have that kind of shotgun. We get into other kind of funky little rights here called piggybacks and drag-alongs and that kind of thing. And what that is, for example, a piggyback is if you want one shareholder who is selling and to a larger company, and let's say that is you got a majority shareholder who owns 90% of the shares. And you've got a larger company saying, hi, I'm going to buy your 90% of the shares. And the minority shareholder, the little guy with 10% here, is saying, hey, don't forget about me. I want part of this deal too. And you might have the large company say, we're not interested in your 10 shares, don't need them. And the 90% shareholder says, yeah, bugger off. I don't care about you anymore. I'm going to make this good deal. With the piggyback, that minority 10% holder gets to say, hey, I'm jumping on your back. I'm piggybacking. You have to bring me along on this. You cannot sell your 90% without also the purchaser agreeing to buy my 10. The drag along is the opposite. It's the 90% shareholder that says, I want to sell. I've got a great deal. And the 10% shareholder says, nah, I'm going to keep my 10%. Your purchaser wants 100 and tells your 90% shareholder, if you don't bring that 10% along, we're not buying. Okay. The drag along allows the 90% shareholder to drag the 10% shareholder along and force him to sell his 10% along with you. All right. So these are kind of the more funky things that we can do with shareholders agreements, but it's intended to avoid a future dispute where these kind of things might come up. And then you get into things like rights of first refusal and options, and one wants to sell and one doesn't want to sell, and what happens in those circumstances. Other items that might typically be covered in a shareholder agreement, you will want to cover situations where you have a shareholder that's become insolvent, on the verge of bankruptcy. So the last thing you want is your partner's shares to fall into the hands of a trustee in bankruptcy. And typically the agreement will provide that if one shareholder has become insolvent and the shares risk falling under control of a bankruptcy trustee, that the other shareholder will have the right to purchase the shares from that insolvent shareholder and cut off the rights of the trustee at that point to gain control of the company before the shares are sent into the bankruptcy. Often that will be at a discounted purchase price, kind of to punish the bad shareholder who's become insolvent, but also to allow the good shareholder, the nice shareholder, to be able to gain control of the corporation. Very important, especially in a family situation as well. If the transition of your business is going to a family member or an employee and you're staying on as a shareholder, is what happens on the death of a shareholder. Now, assuming, for example, again, assuming Renee and I, by way of example, are strangers, we're both shareholders, and Renee dies. I don't want to go into business with her husband, who is essentially Renee's estate, who will inherit her shares. And the husband has no interest in going into business with me. He wants nothing to do with it, but he wants the money, the value of the shares. So typically your shareholders agreement will require the corporation to buy back the shares of Renee from her husband, who is required to sell the shares to the corporation. And we provide for life insurance to cover the cost of that buyback. So that's a streamlined, simple way of making sure that on death, the control of the corporation remains with the shareholders that are still living, and not create a situation where you have nasty in-laws and spouses that come in and create a situation where people don't want to work together and we're at an impasse. You might also see family law act provisions. So if you have a shareholder that unexpectedly is going through a divorce or a separation, and that shareholder's shares are at risk of falling under the control of a family court order, or falling under the control or being attacked by a separating spouse, the shareholders agreement will create a situation where the non-divorcing spouse may have a right to purchase the shares of the separating spouse, to make sure, again, that control of the company stays with the non-separating spouse, and to make sure that those shares don't fall into the hands of the nasty ex-wife or ex-husband.
Luke, only because I think it's on the same theme. There's some questions there, if you don't mind.
Yeah, okay, so I can just open this. Yeah, what are the implications First, Paul Brunet said, good explanation. I'll presume that was for me, not for Renee. What are the complications if you are or want to transition, sell your share, or give your share to your family member, child, or children, and they are in a common law relationship or a serious relationship? Often the best way is for that child to get family law advice and deal with this through their own cohabitation agreement or marriage contract, to make sure that they are isolated from having to dispose of these shares or the assets if ever they split from their spouse. But also, we tie back to what I just talked, and I guess, Benji, your question came in after, but they're in the shareholders agreement, we deal with that in the family law provisions as well. Can a shotgun offer, purchase or sell be triggered for one or two shareholders in particular if there is a 3 to 5 shareholders? Yes, depending on what the agreement says. All right, so it can be crafted that way, but you have to look at the agreement, see what the right is. Can the shotgun be triggered by one on another? Yes, but it often isn't drafted that way. But if you want to provide for that possibility, it can be drafted to provide that right. Okay. Special considerations for family transfers. Parents may want to retain control, buyback, preference shares. So this is the situation where you've got mom and dad are transferring the business to the kids, but they want to retain some kind of control. So we'll often see the parents keeping a number of the voting shares, a majority of the voting shares, until they're paid out in full. So if the kids mess around and are kind of dragging down the company and making a mess of things, the parents can step back in with their voting shares, clean out the board of directors, regain control of the company, and put it back in the right direction. Often we'll see other important things. They seem minor but important for some parents, and we'll see that in a shareholders agreement, or maybe an employment or consulting agreement with the parent, where the parent says, well, while I'm still here and I'm not paid, I want a gas card, and I want you to provide me with a truck, and you're going to pay the insurance, and I want an expense account, and I want a credit card, so we can deal with these items either in a separate employment or consulting agreement. But if the parent is only a shareholder, these particular items that are important for the parent can be addressed in the shareholders agreement as well. I think, yeah, so that's it. Am I talking about the death? I'm on the death, Renee? Okay, we'll move to number 3 now. So this is the transition that will occur, whether you like it or not, on death. And we could go on talking at some length about estate planning and wills and powers of attorney by themselves, but we'll pay particular attention here to these items as they might apply in a transition of a business situation. And again, you might have a really good understanding of these documents, so forgive us for maybe saying things that you already know, but sometimes it's a good idea to just get back on the same page and back to some basic concepts. So first of all, powers of attorney. So powers of attorney are the documents that are used to govern the affairs of someone because that someone is incompetent and unable to make his or her own decisions. The document is called a power of attorney. The person who's got the power to make those decisions is called the attorney, not to be confused with an executor or an estate trustee. Those are the people in charge when under the will. In Ontario, there are two types of powers of attorney. There's the power of attorney for care. So this is the power of attorney for your personal care, the power that you grant your spouse, your partner, the power to make medical decisions for you, consult with doctors, consent to treatment, make end-of-life decisions, that kind of thing. The other power of attorney is the power of attorney for property, and that's the power to make financial decisions, go to the bank for you, run the business, pay things, do your tax returns, buy things, anything that's financially related. In the business context, we would be looking at, and if you're transitioning soon or not, the favored position is for you to have a power of attorney in place in the event you should become incompetent, whether you're transitioning now or you're thinking of selling at a future date. And that's dealt with through a power of attorney for property. Now, most people will just have a general power of attorney where the husband appoints the wife or the wife appoints the husband or children, and saying, look, if I'm incompetent, you can care for my property, you can look after my finances, go to the bank for me, pay my bills, all that kind of stuff. In a business context, you might want to split the two. I'll give you an example. In our particular example here at the law firm, only a lawyer can operate a law firm. It's permitted by law for a non-lawyer to have control and ownership and exercise that kind of power over a law firm. So I would have, in my particular case, a general power of attorney appointing my spouse to be able to go to the bank for me and pay my bills and sell the house if we need to and look after my personal affairs. But a narrow power of attorney that I might grant to someone like Renee or another law firm partner, allowing for the management of the law firm strictly if I become incompetent. So you might have a case where you have a spouse that's granted the general power of attorney, but a child who's involved in the business be granted the business power of attorney. So during your incompetence, your child or your business partner can exercise the power of attorney for you and look after the management of the business details. Before we move on to the wills, I presume that you've heard the term probate before, and often we want to avoid what's called probate when someone dies. And I just thought I'd explain it really quick. Again, forgive me if I'm telling you stuff you already know, but often it's a misunderstood term and it's a misunderstood process. And if you speak to some of the old guys at the Tim Hortons in the morning, they'll tell you if you have to probate, the government's going to take half your money. Okay, that's not the situation. And we have to understand exactly what probate is. So I'll give you an example. If I have, I don't know, well, let's say you have $40,000 in a bank account in your name alone, and you pass away. And your spouse goes to the bank and says, my spouse has passed away, and there's 40,000 in his or her account, and I want access to it because I have to administer the estate. And look at here, I've got a beautiful will, I've got my identification, and I've got my husband, my deceased husband's or deceased wife's death certificate. Give me the 40,000. The bank is likely to say, sorry, not good enough. And what the bank is saying, although they don't necessarily realize what they're saying, but what they're saying is, how do we know this is the deceased's last will? How do we know it's a good will? How do we know that you were not separated at the time of his or her death and there's another spouse there who has rights? How do we know this will is legal in Ontario? How do we know it's properly witnessed, et cetera, et cetera? So the banks will want to cover their own butts, and they will require an extra step. And that extra step is what we call probate. And what probate essentially is that the poor spouse who wasn't able to access the 40,000 will go into a lawyer's office, and the lawyer will prepare a stack of documentation that will ultimately go to the court. And it consists of an affidavit and an application to the court to go through what's called the probate process, or an application, technically an application for a certificate of appointment of a state trustee. And that documentation goes to the courthouse, and it lands on the judge on a judge's desk, who will review everything and conclude that yes, the will is valid, and the person who is named as an executor is named validly as the executor. So all the probate process, all it is the court approving the will and recognizing the validity of the appointment of the state trustee, the executor. That's all it does. It's the court recognizing the validity of the will and the appointment of the trustee. And the court will issue a nice certificate. It actually is a certificate with a little gold star on it. Could be red. And it will, with that certificate, now the spouse can go back to the bank and say, I've got my certificate of appointment now, please release those funds. and then the bank is required to release the funds. And we typically need that certificate to do two kinds of transactions when someone dies: to deal with monies in financial institutions where that money is held only by the deceased person. They're not joint and there's no beneficiary, or to deal with real estate of the deceased person where, again, that property is not owned jointly with someone. Now, the catch is when we send that nice legal documentation to the court is going to say, what's the value of the estate of the deceased person? And you're going to declare that value, $200,000, $500,000, $4 million, and the estate's going to pay approximately 1.5% of the value of the estate as essentially what is a probate tax. So we want to be able to avoid that kind of situation and minimize the probate tax that might be payable by the estate on death. And in a business context, and I'll move to number 3 here, where you might have what's called a primary and a secondary will. And some of you may have heard the term a corporate will or multiple wills. They're often called primary and secondary wills. And what we do here is we do 2 wills. First will deal with the personal assets of the deceased person: house, monies in a bank, furnishings, vehicles, that sort of thing. The second will deal with the shares that you may have in your company. So let's say you have $2 million worth of assets. There's $1 million of houses and cottage and monies in a bank, and you have $1 million of your shares in your company are worth $1 million because of the investments you have in your company. We split those assets in 2 wills, and the 2 wills are essentially identical. And one says this will deals just with my primary estate, being my personal assets, and it deals not with my shares in my company. And I appoint my spouse as my executor, and if I die, everything goes to my spouse. The secondary will says this deals just with my shares, not with my personal assets, and my spouse is my executor, and if I die, everything goes to my spouse. So they're essentially identical. But the thing is here is if we have to go through probate, we only have to because we have to deal with a bank account or a house or something, because it ended up not being joint or whatever. We only have to pay to probate the primary will. So now we pay probate tax only on the $1 million, which are the personal assets, and we don't pay the tax on the $1 million, which is the value of the shares. And the reason for that is we can transfer shares between spouses to kids or to a third party without probate. There's no bank manager there. There's no land titles registrar telling us that we need probate to transfer shares. So that's why you might have heard, the term corporate wills and primary wills or multiple wills, and that's why we do that thing. They could have different executors and beneficiaries. Often they are the same people, but to keep things consistent. But that's essentially what we're doing there on the primary and secondary wills. Finally, your wills will deal with typical stuff. You'll appoint executors. That's the person in charge of your estate. You'll name your beneficiaries. Those are the 2 primary things that the will does. But in a business context, you might have in your will have a first option given to a child to buy a business before it's sold. You might have instructions to your executors to have some trustees in place to deal with the business until it can be sold. So through the wills and the powers of attorney, there's a possibility of intertwining your business planning with your estate planning, so that in the event of incompetency or death, you're able to address the business transition as well. I think that's it, Renee, on that slide.
Yep, you're on a roll, so I didn't want to stop you.
Okay, so Renee's going to address the last issue, which is some of the other issues that come up on death. And I think that's going to be pretty much it for a presentation once this is done.
So some of the issues that might arise on death are taxes, so they're unavoidable. to some extent. When you die, you're deemed to have sold everything that you own at fair market value. So you haven't really sold it, but the Canada Revenue Agency looks at it as though you have sold it while you're alive, because you can't keep owning things when you're dead. And that can give rise to some taxes. So, for example, you own a house, you own a business, you own a cottage, and you have real estate involved in your business. So you only have one principal residence exemption. So you might not have taxes on your house, but then you have taxes on the deemed sale of the real estate from your business, on the shares that you own in your business, on your cottage. And that tax can be very, very expensive if you have assets that you've purchased a really long time ago and are now worth a lot of money. So some business planning may involve having some life insurance in place to ensure that your estate can pay the taxes that arise on death. Otherwise, the estate might be forced to sell the company, sell the cottage, sell your assets to be able to pay the taxes that arise. So there's no death tax like there is in the US, but there is a tax on the assets that you own that are deemed to have been sold on death. And you're able to consult with an accountant and ask an accountant to help you determine exactly, if I die tomorrow, how much will my tax liability be? And an accountant can do that calculation. And so you have an idea of whether or not your estate would be able to afford those taxes on death, or if you need to plan for the estate to be able to pay those taxes with things like life insurance. The will can provide for control of a corporation. So my dad touched on it a little bit. But let's say that a parent was selling a business to a child and the shares had not all yet been redeemed. The parent was still involved. And then the parent dies and the shares are divided between all their children equally. There may be provisions in the will that would allow the remaining child to purchase the shares from the siblings in order for the child involved in the business to continue operating. There may be provisions in the will where loans made to a child are forgiven, but other gifts are made to other children so that the child that purchased the business doesn't have to keep making payments, but on the flip side, doesn't have to pay the value to the other children up front, because that can be really onerous for the child that owes money to the parent when the parent dies. In terms of trusts, you may have heard in the past that testamentary trusts were used for tax planning. That's not really the case anymore. It's not super advantageous from a tax perspective to have trusts created through wills in the same way that it was advantageous in the past. The main purpose to have trusts now is to allow for control. So you may have trust provisions in your will that say that your children will inherit everything once they reach the age of 25. And until they turn 25, your executors are going to manage the assets for your kids. You may specifically provide that your executors are to keep operating the business and for the shares to be transferred to the children when they turn 25. And then your executors can delegate management tasks to current employees. Or you have other provisions that say, no, absolutely not. I wish for my executor to sell the corporation when I die and for the money to be held in trust for my children until they reach the age of 25. Family Law Act. So wills can provide for spouses to be specifically excluded in the case of a divorce. So you leave money to your kids. They're married at the time of your death. A few years later, they get divorced. Often the intention is that the gift that they got from you on death is excluded in the case of a divorce. And there's some circumstances where it would not be excluded, but generally speaking, there can be some planning done to make sure that spouses are not entitled to 50% of their inheritance on a divorce. And finally, if you haven't done any succession planning prior to death, so things can happen. Someone can die young, or you get busy and you never think about your estate planning. There is some post-mortem planning available for families when a business owner passes. Most of these planning opportunities are only available if the business was incorporated. So if the deceased business owner owned the assets personally, there's often not that much planning available. as opposed to a corporation. But to do that kind of planning, again, theme of today's presentation is you'd have to consult with an accountant to see what's available, if it's worth the cost, and what are the risks of being involved in that type of planning. That's essentially it, I think, for presentation today, subject to any questions.
Yeah, just to tie in on that, Renee, and I'm going to repeat myself on the importance again of the accountant. And often in the business context, but just in the general estate planning that we do, sometimes clients are not fully aware of the tax liability that may happen on death, particularly if it's a death of the last spouse, and we can't do rollovers of RSPs and that kind of thing. But there are tax liabilities that will arise from the disposition on death of RIFs, RSPs, an interest in the business, and cottages are a big one now. So for all those folks who bought a cottage on McEwen Lake in 1972 for $15,000 that is now worth $1.2 million, there's an issue there. And our advice to people generally is to have that discussion with the accountant and ask that one simple question, as Renee mentioned, on my death, what is the tax liability to my family? Whether it comes from that cottage, whether it comes from a capital gain on a business interest, or whether it comes from the taxable amount that will be payable on the disposition of RSPs or RIFs. So again, I can't mention enough to have that discussion with your accountant to have a good appreciation of the liability that might hit your family on death.
We have one question that came in. What's the best option for a young professional working in the office that wants to pursue a purchase of the business when they just graduated in terms of financing? Did you want to answer, or do you want me to answer?
Well, yeah, there are different possibilities, and I'll let you correct me after, Renee. There are different possibilities. As part of your employment contract, a young professional can work into an option agreement with the clinic, the owner of the clinic, to buy shares over time, and that might be one way of doing it. The other way of doing it is when the relationship gets serious and the employer really wants to keep that employee or the young professional. Apart from potential option might be to grant that employee a first right to buy the business, so that the young professional is not in a position where they feel that they're working really, really hard, only to see the business be sold to someone else and they're left out of the cold. So we can deal with that first right to buy it, first right of refusal, or with a potential option where they can buy in at a given time or incrementally. Does that make sense to you? Yeah.
Another option would be for the seller to finance the sale. So in a kind of promissory note situation, similar to an employee, a child buying from a parent. So the professional owning the corporation at the moment would say, okay, I'll sell you 25% of the shares for $100,000. Let's say that's the fair market value, and you pay me back over time. So that way the young shareholder receives dividends from the corporation and can pay back the selling shareholder over time.
Gilles asked a question, can you add your child on title before death to help with the tax issue payout? So two things there. Number one, if we're talking about taxes, if you mean capital gains tax that might be payable, the answer is no. There's no way to avoid the capital gains tax that might be triggered on death. The only way to do that is if you have a spouse and it can be rolled over, but that's just putting it off because the tax will be payable when that spouse dies. If you're talking about probate tax, again, the old guys at the Tim Hortons will say the government's going to take half your money, put your kids on the house. That is a way to avoid the probate tax being payable, because now on your death, you have your house that's held jointly with kids, and the house will go automatically to the kids without the need for probate. The downside, there's a dark side to that too, because once the kids are added on the property, and we could talk about this at some length, but the downside is once the kids are on the property, there are a number of bad things can happen, and we've seen all of these things. One, you can't deal with your real estate without your kids consenting. Two, the property might inadvertently be dragged in the child's bankruptcy or a lawsuit that's made against that child, and creditors are seeing that that child has an ownership interest in that property. It could create a trigger of tax on your part, or potential tax problem for the child if it's not clearly structured or properly structured. You could see a situation, and I've seen it, where the child unexpectedly becomes mentally incompetent and cuts all contact with you. And now you cannot deal with your property because you can't reach your child and you need the child's consent. You could see the property be dragged into the child's matrimonial dispute on a separation or divorce. So it has to be considered very carefully. We'll sometimes do it for very elderly parents who are in the very last stages of their life and they want to do that kind of tax planning. But adding children to title has a downside to it, and it really should be explored properly before that kind of thing. Yes, someone said it can be a train wreck. It often is, but it can be done. And sometimes I'll say, well, we do it for elderly parents. You might have mom now who is 85 years old. She still has a cottage. She's not going much anymore. And now she wants to make sure the kids have it. Well, yeah, we'll transfer it to the kids or put her on as a joint owner. Mom is no longer worried about the bankruptcies and the divorces and all that kind of stuff, because now the kids are more stable. The kids themselves are 60 years old, so the context is a little bit different. So we really have to look at the whole situation. All right, I don't know if there are any other questions, but if not, Cameron, we'll pass it on to you.
If anyone has any questions after the presentation that comes to mind, please do feel free to reach out.
Yeah, for sure.
Thank you both so much. It was great to hear all of the details, and I know we had some great questions. If anybody does have any other questions, please drop them in here. For those of you who registered today, we will send the recording, so you'll be able to go back and take a look and see if you have any further questions. Luke and Renee, we're kind of curious, do you want to talk a little bit about what your succession plan has been, and, kind of when you started having that conversation? And I know we spoke earlier about, preparing for today and sort of the back and forth that you might have, just to give a little bit of insight to the attendees.
Yeah, Renee's succession plan is to kick me out as soon as possible and put me in a home. That's her plan. No, seriously, one thing we've done, and this is not necessarily strict succession planning, but one thing we've done, and it seems obvious, but a lot of people don't do, is we've, I brought in Renee into the nitty-gritty of the business. So should something happen to me, she's got a power of attorney. She knows the passwords to the bank accounts. She's aware of the, the employment structure. She's aware of her banking arrangements, and a list of people she can speak to, and sometimes when children or favorite employees are kind of just transitioning into the business, you might want to identify certain people that they can trust and go to. So, if I should pass away and you've got problems with employees, here's the guy you should speak to. If I should pass away and you're not sure of the banking issues, well, here's the banker that really knows our stuff, and make a list of all these key people. All right. And we'll often advise business owners to identify a key manager, because if there's no succession plan in place, you might want to have a discussion with your kids who are not interested in the business. Okay. But they're left with the business and you're suddenly gone. And you might want to identify a manager that they can trust and appoint that manager and say, okay, you're in charge now. Dad's died. We're asking you, here's a bit of a bump in the raise. You're going to be in charge of the business until we can sell it. So that the kids are aware of who they can trust and who they can, turn to, that kind of thing. And as far as actual buyouts, I mean, there are different things that we can be creative about in a situation like Renee and I. And you might have a business that has little value if the key personnel aren't there. You know, I'm thinking of professionals like doctors and chiropractors and clinical people. You know, if you have a large business with equipment and inventory, and you know, there's value to the business even though the owner's not there anymore. So they're kind of treated a little bit differently. So you might have a situation that is similar to Renee and I, where you know, she takes over gradually. There's a buyout, and I would stay on for a number of years to ensure that smooth transition and make sure clients, you know, are comforted that, you know, there's still some stability in that kind of thing. So those are some of the issues we'd look at in that kind of succession planning. Something to add, Renee?
And I mean, I know for the chamber, we're just, you know, keep talking about succession and mentioning that it's never too early to start having those conversations. And I'm just curious from Renee, sort of, when did you know, what was your experience like? When was that conversation, you know, starting to be had at the dinner table? You know, were you still in grade school? What was that experience
Yeah,
like
when she
for
was
you?
12 years old.
Yeah, probably, right? Yeah, what was that like for you, Renee?
No, really, it was only when I decided to come back to Timmins, which was only when I was in law school, that we started thinking about it. But one thing that we do think about, and that everyone should think about, is that most succession planning strategies will take at least 2 years to implement. And that applies to us, it applies to most corporations. So you want to make sure that you consult with an accountant at least 2 years in advance. And that we're looking at the books, we're looking at the corporation at least 2 years in advance to make sure that when he does want to exit, whether it be all at once or gradually, more likely gradually, the corporation is set up in a way that allows him to do that.
That's great, thank you. And we had someone inquire if you're comfortable sharing the slides, Renee, and if you are, if you can just send them over to me, and I'm happy to share it with the group as well.
For sure, I'll send them to you. They're a little bit slim, but at least they can remind you of the issues that we talked about.
Perfect. Well, if there are no other questions, thank you so much to both of you for doing this, and happy that it jarred some conversations in your office on as you're preparing this. And the chamber's happy to continue to have these conversations with our members, because we know how important it is, and we'll keep hosting sessions. If you have any feedback on today's session, you'll have the opportunity to send that over to us when we send the recording. So thanks again. Enjoy the rest of your day. And
thanks, Carmen. And again, we'd be happy to, if anyone has other questions or want to talk about a particular item, just give us a call anytime.
That's great. Thank you so much for that offer. Enjoy the rest of the day.
Thank you.
Bye.